Hello friends, welcome to our channel Khatri Steno. Subscribe our channel for more dictations on daily basis. Get ready for the dictation without any stop. The Law Commission received a reference from the Ministry of Home Affairs, Government of India, wide letter dated 29th March 2016, addressed to the Department of Legal Affairs, Ministry of Law and Justice, with a copy to the Law Commission of India for a study of the usages of the provision of Section 124A of the Indian Penal Code and suggest amendments if any. The said letter also mentioned that since the Law Commission is already undertaking a comprehensive review of the criminal laws, it may also look into the issues relating to Section 124A of the IPC during the course of such review. Here it is also pointed out that wide letter dated 7th July 2010, the then Home Minister made a reference to the then Law Minister for a comprehensive review of the criminal laws by the Law Commission of India, and accordingly the Department of Legal Affairs sent this reference to the Law Commission wide letter dated for 14th June 2013 for a comprehensive review of the criminal laws. As far as the comprehensive review of the criminal laws is concerned, it is pertinent to note that the 21st Law Commission started working on this project in piecemeal and submitted 6 reports, namely report numbers 264, 267, 268, 271, 273 and 277, covering various aspects relating to the criminal justice system. The 22nd Law Commission, in its first meeting held on 17th January 2023, discussed this issue of usage of the law of sedition and was of the R3 considered view that it requires a detailed examination keeping in mind the various developments in the recent past. In this regard, the Commission requested the Ministry of Home Affairs wide letter dated 16th January 2023 to furnish their comments. Reminder letters were also issued by the Commission. However, looking into the urgency of the matter, the Commission has discussed this issue with various stakeholders and scholars and made a detailed research on the subject matter, thus finalizing this report. The origin of the law on sedition can be traced back to the English law. In feudal England, sedition comprised those libels and slanders that would alienate the rulers from their subjects. Traditionally, the legal elements of sedition were obscure and thus failed to provide a precise definition. The offences which would now be classified as sedition were prosecuted under treason or under scandalum magnatum or even under martial law. At the end of the 16th century, a newer connotation for the term sedition began to emerge, the notion of inciting by words or writings dissatisfaction oblique disaffection towards the state or its constituted authorities. This secondary definition gave rise to an understanding of sedition as being distinct from treason and not necessarily entailing direct involvement in violent actions but rather serving as potential triggers for such acts. Even though the rights to be included in the Constitution were considered to be fundamental and enforceable by the courts, the Constituent Assembly members very well realized that these rights cannot be absolute. The two strongest advocates of the limitation of fundamental rights